The rule of law is supposed to be blind, but today we're doing a deep dive into two recent legal battles that, well, they suggest political warfare remains the real judge in Washington and New York.
It's a fascinating and, frankly, a deeply concerning study in legal contrasts, and it's all sourced from events at the end of 2024 and into 2025.
Right. On one hand, you've got this huge federal criminal case against a former president just collapsing.
And on the other, you see a retaliatory federal prosecution, this time launched against one of his biggest political rivals, and it fails spectacularly. Our mission here is to unpack how both of these high-profile showdowns just fell apart and, what that says about political justice.
So we've gathered all the details on the federal classified documents case against Donald Trump, and then on the other side of the coin, the mortgage fraud prosecution against New York's Attorney General Letitia James. We're going to trace the very specific technical legal flaws that cause these cases to crash.
And let's start with that news hook because it really sets the stage. Just last month, that's November 2024, Special Counsel Jack Smith dropped the federal classified documents case against former President Trump.
Dropped it completely.
Completely. Abandoned all criminal proceedings against Trump and his two co-defendants, and this was before he even re-entered office. It was a monumental concession from the federal government.
A colossal reversal.
Oh.
But the scrutiny, it's absolutely a two-way street here. Because just this month, December 2025, we saw the counterpunch hit a solid brick wall. A federal grand jury stunningly refused to re-indict Letitia James on charges of mortgage fraud. That just completely derailed a prosecution that was, let's be honest, widely seen as backed by Trump.
And that grand jury rejection is, it's statistically remarkable. You have to understand just how rare this is.
It's almost unheard of, right?
Almost. It is extraordinarily difficult for a prosecutor to bring a case that a federal grand jury just votes down. Look at the stats from 2016. Prosecutors reported this outcome in only 6 cases.
6? Out of how many?
Out of more than 150,000 investigated people.
Wow.
So the rejection of the charges against James was effectively a 1 in 25,000 statistical anomaly. It's a huge signal that the jury saw the case as fundamentally flawed.
So 2 massive political prosecutions. One against the former president, one against his most prominent legal antagonist, and they both fail. Not because of a trial, but because of, well, procedural defects. Okay, let's start where the system first blanked. The Mar-a-Lago documents case. How did that just evaporate?
It was a classic example of a legal case just running out the clock, and it was coupled with a really successful constitutional challenge. The trial was originally set for May 2024.
I remember that.
But Judge Aileen Cannon, who was presiding, she postponed it indefinitely right away back in May 2024. The prosecution, they kept arguing the case involved, and I'm quoting here, straightforward theories of liability.
Meaning they thought it was a slam dunk. Simple fact.
Exactly. But at the same time, they themselves had asked for pretty big delays to handle all the procedural headaches that come with classified evidence.
So they were kind of talking out of both sides of their mouth, saying it's simple, but also saying they need more time for complex prep.
And Judge Cannon's rulings, well, they were decisive. On July 15, 2024, she dismissed the superseding indictment entirely.
Okay, for those of us not deep in the legal weeds, what exactly is a superseding indictment? And why was the appointments clause the thing that brought it down? That sounds super technical.
It is technical, but it's crucial. So a superseding indictment is basically just a revised charge sheet. Maybe you add new defendants or change the original charges.
The update.
Right. But the fatal flaw, the way Judge Cannon saw it, was the appointments clause. It's this part of the Constitution that dictates how major officials, people like U.S. attorneys or special counsel, have to be appointed.
So the idea is if you're going to charge a former president, the person doing the charging better have the absolute legal authority to do so.
That's it in a nutshell. Judge Cannon basically questioned whether special counsel Jack Smith had been lawfully appointed to begin with. He hadn't been confirmed by the Senate, you see, and his authority just came from the Attorney General.
I see.
Her position was that this whole structure could violate the separation of powers. You'd have an unconfirmed official wielding this immense sovereign authority. If the prosecutor's legal foundation is shaky, the whole case built on top of it just falls apart.
In the special counsel's office, they immediately appealed that dismissal. They clearly wanted to keep fighting.
Yeah.
But then they just stopped.
They did, and that's where the political calendar really slammed into legal reality. After the dismissal in July with the appeal pending, the special counsel just chose to drop everything, both the election case and this documents case, on November 25th, 2024.
Right before Trump officially took office.
Exactly. The appeal was dropped. The proceedings against the co-defendants, Walt Nauta and Carlos de Oliveira, were all abandoned by January 2025. It was over.
So after years of investigation, all this public attention, the whole thing ends not with a trial, but with a judge's ruling on the prosecutor's authority. Couldn't you argue then that it was really a political decision by the prosecution to just avoid a messy trial during a change of administration?
That's a very fair point, and it gets to the heart of the political risk here. The documents show that Judge Cannon's ruling on the appointments clause basically gave the prosecution an exit ramp.
A way out.
A way out. Whether dropping the appeal was a purely legal decision or a strategic one to avoid a long war with an incoming administration that would scrutinize their every move, that's up for debate. But the result is the same. It reinforces the argument that when these politically charged cases get brought, they often have these fatal legal flaws baked right in.
And now the pendulum swings back hard. We've seen how the case against the former president was abandoned, so now we have to look at the retaliatory cases. And the failures there are, just as spectacular, starting with Letitia James.
Yeah, this immediately looked like score settling. James, who had so aggressively gone after Trump's businesses, suddenly gets hit with federal charges in October of 2025.
And the charges were bank fraud and making a false statement to a financial institution. What was the actual allegation?
The allegation was that when she bought a home back in 2020, she listed it as a second home on her mortgage documents when it should have been listed as an investment property.
Okay, and why does that matter?
Well, you can sometimes get a better interest rate on a second home. The prosecutors alleged this could have saved her maybe $19,000 over the entire life of the loan.
So not a huge amount of money in the grand scheme of things, but still a serious federal charge.
Oh, absolutely. And James immediately called it what she saw it as. She said it was a, quote, retaliatory move orchestrated by the president and called for the unchecked weaponization of our justice system to stop.
And given who brought the indictment, it's hard to dismiss that perception.
It's impossible to dismiss. The prosecutor who got the indictment was Lindsay Halligan. She had been a personal attorney for Trump.
And she was acting as the interim U.S. attorney for the Eastern District of Virginia. She used that position not only to indict James, but also to get charges against the former FBI Director James Comey on totally separate matters.
It almost sounds like a referee calling a game-winning touchdown, but it turns out the ref wasn't actually licensed to be on the field.
That is a perfect analogy. The whole thing fell apart not because of the facts of James's mortgage, but because of the legitimacy of Halligan's appointment. Judge Cameron McGowan Curry dismissed the indictments in November 2025, ruling Halligan's tenure was simply unlawful.
So what was the technicality there, the 120-day clock?
Exactly. There's a federal statute. The Attorney General can appoint a temporary or interim U.S. attorney, but that power runs out after 120 days.
And Halligan was past that deadline.
Way past it. Judge Curry found the clock had run out back in May 2025, months before the indictments were even brought. And the judge issued this stark warning, saying that if the government's position was upheld, it would let officials evade the Senate confirmation process indefinitely. So it was really a check on executive power. The judge dismissed the cases without prejudice, which meant they could try again.
And they did try. They moved to refile just 10 days later. But this is where we get back to that stunning statistic we talked about. The final nail in the coffin was delivered by the citizens.
The federal grand jury.
The federal grand jury declined to indict James.
The 1 in 25,000 anomaly. The grand jury, which almost always does what a prosecutor wants, just said no.
It was a decisive rejection. As James's lawyer put it, the case should never have existed in the first place. An unlawful appointment plus a grand jury rejection. The prosecution just completely collapsed.
And this whole tit-for-tat drama really only exists because of James's original civil case against the Trump organization. We have to connect these dots back to that financial conflict. What did she do that made her such a target?
Her civil suit was huge. It alleged vast financial fraud, that the Trump organization overstated asset values by as much as $2.2 billion in a single year to get better loans.
And that suit led to that massive judgment from Judge Arthur Engoron in February 2024. He ordered Trump and his companies to pay, what was it, over $450 million with interest.
That's right. It was $354.8 million in what's called disgorgement plus interest, but we should clarify that term, disgorgement.
It's not a fine, right? It's different.
It's different. A fine is a punishment. Disgorgement is forcing someone to give back money they illegally profited from. The court said, look, you saved $168 million in interest from good loans, and you made about $186 million from selling properties like the old post office. You have to give that back.
A debilitating financial blow. But even that victory was challenged as being, well, politically excessive. And this is a key point in the argument about political punishment, the appellate reversal.
A crucial development. In August of 2025, an appeals court looked at the case. They upheld the finding of liability. They agreed that fraud happened, but they voided the massive financial penalty. They essentially said, yes, you broke the rule, but this punishment is unconstitutional.
They took all the financial teeth out of the judgment. On what grounds? How could they say it was too severe when it was based on profits?
The appeals judges ruled it was an excessive fine that violated the Eighth Amendment. Their argument was that the state never really identified any specific victims who lost money because of the inflated valuations. So the disgorgement, especially the part about interest saved, felt speculative and overly punitive. It went way beyond just fixing the fraud.
So even a successful prosecution wasn't immune to being checked for going too far.
Exactly. James is appealing that, but for now, that financial hammer has been taken away.
So what does this all mean for you as you try to follow these high-stakes political fights? We have this duality. Trump avoids federal criminal prosecution because of a ruling on the prosecutor's authority and, well, a strategic withdrawal. At the same time, his main rival in New York sees a case against her completely fall apart because of an unlawful appointment and that rare grand jury rejection.
The key takeaway from all the documents is this. In these huge politically charged cases, it's the technical legal issues that end up deciding everything. A judge's ruling on an appointment, the constitutionality of a special counsel, the Eighth Amendment on excessive fines. These are the things that can just dismantle years of work by prosecutors.
It doesn't matter who is being targeted.
It doesn't seem to matter. The procedural flaws become the escape hatch for the politically powerful, whether they're on the left or the right.
And both sides screamed that the justice system was being weaponized against them. So when you see these massive cases all fall apart because of procedural flaws or constitutional questions, what does that say? Does it show the system is strong, that it's upholding the rule of law and checking power? Or does it just confirm that high-level justice has become nothing more than political score settling, where the winner isn't decided by the facts, but by who has a better lawyer to navigate the procedure? That's the profound question we're left with.